Hi, and welcome to the second video in the employment module. This video will take a look at human rights issues at work. We'll cover how you can help a client who's been discriminated against while working a job. After that, we'll take a look at how you can help a client who's being harassed at work. And finally, we'll wrap up by covering what to do if your client's employer asks them to take a drug or alcohol test. Let's start by taking a look at discrimination. In the last video, we saw how you can help a client who's being discriminated against while applying for a job. But now let's take a look at how you can help a client who's experiencing discrimination while working. In most workplaces in Ontario, employers have a legal responsibility to create and maintain a safe workplace for their employees. This responsibility also requires them to take steps to protect their employees from discrimination. What discrimination looks like can vary, and there are lots of different ways that it can happen. But at its core, discrimination means treating someone unequally or differently in a way that causes harm and that is based on a reason protected under the law. These reasons are also called the protected grounds and include things like a pardoned criminal record, if someone has a disability, including mental illness and addiction, someone's race, color, ancestry, ethnic origin, citizenship, or place of birth, their religious beliefs, their age, marital status, or family status, or their sex, sexual orientation, gender identity, or gender expression. The harm that's caused by discrimination won't always be clear, but it can include things like being fired, or also involve things like dignity, anxiety, or depression. Some examples of discrimination could be someone being fired because of their religious practices, someone not being hired because of their race, or someone not being able to enter their workplace because of a physical disability. But where discrimination occurs, employers have a legal responsibility to make accommodations, to make sure that things are fair for all of their employees. This is also referred to as the duty to accommodate. What accommodation means depends on the discrimination being faced, but generally employers will have to make changes to the workspace or to the working conditions to decrease the effects of discrimination. For example, this can mean allowing a leave of absence for addiction treatment, giving someone greater flexibility for their childcare responsibilities, or providing someone with different software or working equipment. Employers have to make these accommodations, unless it would cause them undue hardship, but that's a high bar for an employer to meet. If your client isn't sure whether they're experiencing discrimination or what they can do about it, you can help them go through the Human Rights Legal Support Center's online assessment tool, or you can help them contact the center directly. If your client thinks they're being discriminated against, you should tell them to talk to their employer or their union representative first. If they might need an accommodation, they can talk to them about this, but they should also put that request in writing. You can also let your client know that they'll need to cooperate with their employer to figure out what a reasonable accommodation would be in the circumstances. When having those conversations, it's helpful if your client makes notes, and you can help them do this by writing down what they say. You should also remind them to keep any paperwork, including emails or texts, that they have with their employer or their union representative. If the employer still doesn't accommodate your client, you should refer them for legal advice to see if they can file a claim with the Human Rights Tribunal. Remember that claims to the tribunal need to be filed within 1 year of the date of discrimination, so it's helpful to get advice early on. They can get legal advice from the Human Rights Legal Support Center, from a specialty legal clinic, or from their local legal clinic, if that clinic deals with human rights issues. Now let's take a look at harassment at work. Because employers have that legal responsibility to create and maintain a safe workplace, they also need to take steps to make sure their employees aren't harassed at work, whether it's by the employer themselves, by other workers, or by any customers. What harassment looks like can vary, and sometimes it can also be a form of discrimination if it goes against the protected grounds we talked about earlier. Harassment can look like someone being threatened, someone being touched without permission, someone being bullied or joked about because of things like their appearance, gender, sexual orientation, or their religion, or someone being told not to speak their own language while on break. When it comes to harassment, it's the impact of the behavior that matters, not the intent. Typically, the behavior will have to happen more than once for it to be harassment, but sometimes just once is harmful enough. These distinctions can make it hard to know whether what's happening to a client is harassment or not. So if they're confused or if they're worried that they won't be able to prove what happened, you should refer them for legal advice. You can also help your client keep a written record of the harassment. This can mean reminding them to take notes about the situation or helping them write things down like the date, the time, the place, what was said or done, and what they did. These notes can be helpful later on and can help them avoid missing details. If they speak with their employer or their union representative about it, they should also make notes of those conversations and collect any important paperwork, like emails or text messages. Finally, let's take a look at how you can help a client whose employers ask them to take a drug or alcohol test. Employers can't usually ask someone for this. It's very rare and shouldn't typically come up for your client. Most employers in Ontario do not and cannot do this. But in some very limited cases, an employer can ask someone to take a drug and alcohol test if they can prove there's a connection between taking the test and the employee being able to do their job properly and safely. This is a high threshold for an employer to meet, though, and something like working with heavy machinery or doing a job that might be considered dangerous won't be a good enough reason to ask for the test. They could request a test if the employee has had previous or frequent issues with using drugs or alcohol at work, if they reasonably believe that the employee came into work impaired, if the employee came back from substance use treatment, or if the employee was involved in a workplace accident. These are just some examples and won't always mean that an employer can ask for this test. So if your client tells you that they were asked to take a drug and alcohol test or that they were fired or punished because of the results of a test, you should refer them for legal advice immediately. And just like that, we've covered human rights issues in employment. Until next time.